Good afternoon, everyone. Good morning, good day, wherever you're located and tuning in to this HILAC lecture. So today's HILAC event is focusing on the humanitarian civilian, and we have with us a great guest, Dr. Rebecca Sutton. I will introduce her to you in a little bit. My name is Rebecca Madavi, and I am a lecturer in international law at the University of Manchester, as well as an associate fellow at the Asser Institute in the Human Dignity and Human Security strand, led by Dr. Pelusin. Welcome to the Asser Institute and to this event. Today's event is organized in the context of HILAC, which stands for the Hague Initiative for Law and Armed Conflict. The HILAC Lecture series has been organized since 2005 by the Asser Institute in cooperation with the Amsterdam Center for International Law and the Netherlands Red Cross. So in today's HILAC event, thanks to our guest, Dr. Rebecca Sutton, we are going to challenge the assumption that there is an essential divide between civilians and combatants and explore the fluidity in the notion of distinction by looking at IHL in action, or as Rebecca calls it, the everyday life of IHL. So we are very happy to have you with us. Rebecca is an excellent and creative IHL mind that I admire quite a lot. So I will now introduce her to you, but I should stress that what follows is just a really brief selection of Rebecca's impressive background. So my apologies in advance. So Dr. Sutton is a Leverhulme Early Career Fellow at the University of Edinburgh, where she conducts research on the role of emotions in humanitarian negotiation and in IHL pedagogy. She will be joining the University of Glasgow as a senior lecturer in international law in January. And she received her PhD in international law from the London School of Economics in 2018. And she has held positions at the EY, at McGill University, Melbourne Law School, and the Oxford Institute for Ethics, Law and Armed Conflict. Her first book, The Humanitarian Civilian, was published by OUP this year in February, and her scholarship can be found in various top journals, the African Affairs and Leiden Journal of International Law. Throughout the COVID-19 pandemic, Rebecca has engaged in participatory action research with young Rohingya refugees in Cox's Bazar in Bangladesh. And in 2020, she piloted a new module, quite interesting, on emotional intelligence and conflict resolution for LLM students at Edinburgh Law School. Rebecca, thank you so much for making time in your busy schedule and for accepting our invitation. So we'll start with your presentation for about 30-35 minutes, and then we'll have a Q&A session with you, the audience, and you can already type in your questions in the chat. I will pass them on to Rebecca after her presentation. I spoke enough. Rebecca, congratulations on your great book, and you have the floor.
Thank you so much, Rebecca. And I will tell everyone else this, but whenever Rebecca calls, I answer the phone. So we have a sort of long-standing friendship and intellectual collaboration, and I'm so excited to continue it. I was delighted to be invited by James and Rebecca to give this HILAC lecture. It's a real honor for me. And I've had some amazing visits to the Asser Institute, and I only wish we could be together in person, of course, today. And also let me congratulate Rebecca. It's her first day at Manchester. So congrats on your new role there, Rebecca. So what I'll do, as Rebecca said, I'll speak for about 35 minutes. I'll be using slides. But really what I'm aiming to do in the presentation part is to just give us a shared foundation so that we can talk more informally in questions and answers. So please keep your questions, make them fiery, and hopefully we can have some interesting debates after I've gotten through the slides. And I'll also say that if you make it to the end of the slides, there is a discount for the book. So I will share the little incentive for you. I'll share the book's discount code as well. All right, so let me just try to share screen here. And Rebecca, maybe if you can just confirm for me that I have it set well. How does that look? Great. Okay, wonderful. Okay, let me just set a timer to keep myself in line. I'm going to aim for 35 minutes here. All right, okay. So the humanitarian civilian. Now, in this presentation with these slides, I'll be speaking mostly about the book, but the book is really the culmination of a 7 or 8 year project that began for me in my former life as an aid worker and continued through the PhD at the London School of Economics, and then was transformed into a book over the last few years. It's just come out in February. And I think what is most useful is maybe if I give you an overview of the book itself and the project, and then I'll highlight the main arguments that I advance in the book. And then I'll spend actually quite a bit of time on methodology so that I can explain what allows me to make these claims or these arguments. And I do have slides on the structure of the book, but I think they're maybe a bit less interesting for our HILAC purposes today. So I'll probably not go to those. Okay, so this is the book, The Humanitarian Civilian, How the Idea of Distinction Circulates Within and Beyond IHL. And this project really comes for me from the field of humanitarian practice. So when I was, let's see, this was 2009 to 2011, I was living in West Darfur in Sudan, and I was working for a humanitarian NGO called War Child Canada. And I was in the role of country director for that organization, which meant that I participated in high-level discussions amongst the humanitarian community about how we should present ourselves in Darfur, how we should interact with peacekeepers that shared the operational space, whether we should use military assets, whether we should do human rights work or long-term development programming. And something that I noticed in this humanitarian role in the field of practice is that when we thought about how we should interact with others in the operational space, we routinely formulated the problem as a problem of distinction. So we would say something like, we need to distinguish ourselves from the UN mission, which at that time was UNIMID, the AU hybrid UN mission. And I think what's interesting in hindsight is I, at that time, was not trained as an IHL lawyer, but I then went back to law school in Canada and got the JD. And there I was learning about IHL as lawyers understand it. And when I learned about the principle of distinction as a legal rule, I struggled to grasp with, to understand what this targeting rule had to do with our distinction practices on the ground. And something else I noticed in practice that really just came with the benefit of hindsight was that when we talked about distinction in Darfur, we would often collapse distinction as a targeting idea together with other things that were important to us. For example, signaling visibility for donors, or signaling to beneficiaries that we could be trusted as good humanitarian workers. And so I knew that there was something going on with these practices of distinction, and I knew that I had a significant puzzle to solve. So that's what sent me off on the PhD. So for those of us in the room who might not be IHL lawyers or steeped in these rules, let me just say something briefly about the principle of distinction. So as delineated in Article 48 of the First Additional Protocol of 1977, the principle of distinction delineates the difference between the civilian and the combatant. And in essence, what it does is it says that everyone who falls on the combatant side, or anything that is a military objective, can be a legitimate target under certain circumstances, and if certain rules are followed, these things and these people can be targeted in war. Then the civilian and civilian objects are to be protected from intentional targeting under IHL. And basically what's, in terms of how this rule circulates in normative and doctrinal debates, really the dominant vision is that the civilian and the combatant are divided by a bright line. So we have a bright line and it's alternative and exhaustive so that everyone has to fall into one category or the other. And if you're in one of the categories, you are not in the other. So that's the idea about how the principle is supposed to work. And the main contribution of my project and my book is to build on the work of scholars who have showed that in practice, this distinction is quite fluid. And what I do in my project is I pivot. So instead of looking at the conduct of hostilities in the general civilian population, I turn our attention towards a different set of actors whom we often don't discuss in connection with the principle of distinction. And who these actors are. So my main character is the international humanitarian actor. And here I include people working for the ICRC and other Red Cross family organizations, UN humanitarian agencies like UNICEF and UNHCR, and also humanitarian NGOs like the one I worked for, or like Mercy Corps and Oxfam. So the humanitarian actor is my main character. And what I wanted to understand is how are humanitarian actors producing distinction in their everyday practices? Now, if I wanted to understand that, I couldn't look at the humanitarian actor in isolation for the simple fact that humanitarians can't distinguish themselves in isolation. Everything about distinction has to be worked out in relationship with others. So my attention got drawn to these international missions, which are usually referred to as comprehensive missions. And in these missions, you'll have soldiers or peacekeepers, and they could be working, it could be under the aegis of the EU or the UN or NATO, for example. And these different military and peacekeeping actors will be instructed to work together with each other and with humanitarians and with other international civilians. And so these comprehensive missions have this ethos of walls coming down, the boundaries between different international actors being collapsed. And I thought that would be a really interesting site to think about the tensions around distinction, because distinction would theoretically have everyone remain in their respective spheres. And so I look at UN peacekeeping actors in particular. I look at the blue helmets who populate battalions or UN forces. And I also look at civilian staff who do human rights work, for example, for the mission. And then I look at international military actors, especially at trainings, and I'll explain a bit about that later. And so it could, for example, be NATO forces in Afghanistan and that kind of thing. And so what I wanted to understand is on a daily basis, in conflict zones and at training, in training spaces, how do humanitarian actors assert a distinction from these other actors in their midst? So that's the project in a nutshell. And all that I'll do with the rest of the time is flesh out some of it in more detail. So let me say something about my main arguments. These are about the everyday life of law, distinctions perpetually disrupted nature, and my claim that there's in existence a civilian plus figure in international practice. And that last one is the most provocative and controversial, if you will, and one that I think we could debate for days or 30 minutes, however much time we have. So let me say something about sociolegal approaches, because I think this is something that not all international lawyers would be familiar with. What I wanted to do in this project was really to make a methodological contribution. So what I noticed is that international lawyers, including IHL lawyers, had been slow overall to engage with contemporary humanitarianism. So they weren't meaningfully engaged with the rich literature on humanitarianism that we could find in the field of humanitarian studies. And what I did find is that when IHL lawyers turned their minds to humanitarianism, they tended to take a more normative and doctrinal approach. Now, I think there is a good reason to do that. For example, there are many things we need to clarify about law's application to aid. So if we think of even a topic like cross-border humanitarian aid, we need to know from a normative and doctrinal perspective, how does the law apply? What are the legal rules and what should they be? And so I don't dispute the importance of that work. And indeed, I do some of that work myself elsewhere. But what I wanted to do in this project was do something different. So I wanted to show what we might learn if we took a more critical and sociolegal approach to thinking about IHL and about humanitarianism. So I found that sociolegal studies and an emphasis on law in everyday life was a really useful way to think about distinction practices. And so building on Sally Angle-Mary and Surratt and Cairns, I'm thinking here about the sociolegal approach to IHL. And what we could do if we took this lens is we would think about law's instrumental as well as its constitutive aspects. So if we're thinking about a place like South Sudan, the instrumental role of law would be to look and say, how are humanitarians using law, promulgating law, avoiding it, ignoring it, challenging it, undermining it, developing it, and so on. But now in law's constitutive role, law is also constituting these actors, and law is shaping and limiting what they can do with it. So even if humanitarian actors in South Sudan don't talk about the principle of distinction on a daily basis, the fact that they identify as civilian in the sense of being legally entitled to civilian status will shape everything that they do, especially in terms of how they interact with others who they identify as civilian or a combatant in the operational space. And so sociolegal approaches really help us get at this twofold role for law. And I wanted to build on critical humanitarian scholarship that showed the gap between theory and practice and bring in a legal perspective to that scholarship. And then I wanted to infuse what Mark Dromble calls the international legal imagination with the insights of everyday humanitarianism. And so I tried to put these two fields or these two disciplines on an equal footing so that they were not in a hierarchy. So I did not situate law, even though I'm a lawyer. I'm actually a social scientist first. So I really had I didn't want to rank law above the humanitarian literature or something like that. I really see them as in conversation with each other. So that's a claim about the everyday life of IHL. Now, distinction being perpetually disrupted. So this is where it really becomes important to talk about why this isn't a study of legal compliance. So if I was doing a study of IHL compliance, I would have set out to ask a question like, are humanitarian aid workers following IHL in conflict zones? Are they complying with the rules? Now, if I did that, there would be two drawbacks. And I would say that that would be a valuable study as well. And indeed, those studies are underway and we have many of them. So they're very valuable for what they do. But the two drawbacks are as follows. First of all, if I ask a compliance question, I'm going to assume that the civilian combatant distinction is actually the distinction that matters most. That is the distinction of greatest significance. And that might lead me to overlook things like civilian-civilian tensions. And what I show in this study is that sometimes in practice, civilian-civilian distinctions matter more than civilian combatant distinctions. So I would have missed that if I focused on compliance. Second, if I focused on compliance, I would focus on the principle of distinction and all of the practices that didn't seem to implicate it or relate to it directly. I might think that they are violations of law, or I might think they're just irrelevant and extra legal and dismiss them. So I would have missed so much of the picture that I eventually was able to present. And what I tried to do in this study is I don't make the claim that practices on the ground are disordering or causing chaos for a rule that's otherwise tidy. Instead, I show that at every level, distinction is messy and chaotic. And this is true in South Sudan, where we find humanitarians living together with UN peacekeepers in protection of civilian sites. And it's true at civil military training spaces, where we find trainees disputing distinction and playing games with distinction and simulating it. And it's also crucially true at the level of codified rules and legal doctrine and theory. So even in the Geneva Conventions, distinction is messy. And to show that this is the case, I only have to point you to the rule on direct participation in hostilities, which dims the line between the civilian and the combatant and allows for civilians to be targeted for such a time as they participate. So that's just one example of an IHL rule that starts to insert a bit of chaos into the idea of distinction. So that's really what the book tries to do, is make a bottom-up argument about distinctions disorder. And it's difficult to sit with intellectually, because one of the conclusions of the book is simply that distinction is perpetually disrupted. And it's a very uncomfortable world to live in, especially if we're interested in protecting civilians in war. And I think anyone watching the news coming out of Afghanistan in the last week or two may have been thinking about these things. So let me say something about the civilian plus, and this is where the action is in the book. So I showed you earlier a slide that laid out the civilian and the combatant with a line between them. And as I explained there, in this dominant vision, there's a bright line between them and you can't, in theory, hop over the line. Now, what I want us to do for just a moment, I won't make you close your eyes or anything, but just imagine that we put down this idea of a static civilian status and a static combatant status. So we're just getting rid of those entities for a moment. And now I want to conjure a very different vision for you of distinction. And this vision comes from what I found when I studied the practices of humanitarians. So in their vision of distinction, and to clarify, this is not how they verbally present it, this is what I read into their practices. So I'm naming these practices and introducing the words, which comes with ethical obligations we can talk about in the Q&A. But imagine a world in which you don't have a civilian, and we even detach the idea of civilianness from the civilian. So in this world, you just have individuals in the operational space, and there are qualities floating in the air, these floating signifiers of civilianness or combatantness. And civilianness would be associated with innocence, harmlessness, and non-participation, whereas combatantness we would associate with danger, complicity, and so on. And these qualities are floating around in the air, and they could attach or affix to any individual in accordance with how they present themselves, how they behave, how they look, who they're seen with. And so in this vision of distinction, if you're looking to protect yourself by claiming you're civilian, you're not fighting for civilian status. Instead, you're jostling to position yourself on the higher end of a civilianness continuum. So here, unlike what IHL would tell us, here, civilianness is not a matter of category, it's a matter of degree. And everyone is fighting to be more or less civilian, rather than to be civilian or not civilian, if that makes sense. And so we have this very dynamic and fluid kind of vision, and that's how I read the world of practice. So that's what I actually think is going on the ground. But then I wanted to say something to IHL lawyers about what this kind of fluidity and floating signifiers, what that does to our civilian category. And so at the risk of bringing things back into a more static and set kind of framework, I am going to go back there and introduce 3 new civilians. So there's a trade-off there. Again, we can talk in the Q&A. I'm trading a bit of the dynamism for a bit of clarity, so I can talk about concrete status. And the 3 civilians that I introduce would be totally strange and unfamiliar to us as IHL lawyers. So first, there's the civilian plus. And I argue that the civilian plus is the status that humanitarians long for. And it's the status that they desire because in theory, the plus would shield them and provide an extra layer of inviolability. And this would incentivize the important work that they do in war. And it would also recognize the additional risks they face by virtue of the kinds of tasks they carry out and the dangerous situations they work in. Now, to be clear, I should say that humanitarians are not walking around saying we want to be civilian plus. In fact, I think if you did a survey, many of them would push back against this idea and say, whoa, I would never say that. And so to be clear, what I'm saying is, I don't think they're asking for it, though some are actually, there are some accounts of this. But in general, I'm reading it into their practices. So I think that they are behaving in such a way that suggests that they believe there are different civilians to be found, and that in order for them to be safe and to do their work, they need to be recognized as the purest form of civilian. Okay, and that brings us to the mere civilian. So the mere civilian is given to, it's like a default status that's given to you if you're only ordinary civilian. So you've done nothing to attract the plus, but also nothing so combatant-like that you would be seen as minus. So in the old world of the principle of distinction, all civilians fall here. They're all ordinary civilians. But now we've squeezed that category so that it only contains the people who aren't plus and minus. And this is the default status that I think humanitarian practices suggest there's a belief that it's just not enough because the civilian is degraded and questioned and beleaguered. People wanting civilian plus status want to sort of escape the vulnerability of the mere civilian. And this is the paradox of the civilian plus. The reason for the plus is because the general civilian ideal has become so beleaguered historically. But the more that people claim a special status, the more we risk degrading the general civilian protection norm. And that's the paradox. Now, the third one is the civilian minus. So I would argue that this status haunts humanitarian practices. And this is the status they really want to avoid and to shrug off. And what's interesting is, yes, you could attract civilian minus status if you do something really egregious, like direct participation in hostilities. But actually, as a matter of perceptions, what my study shows is that people often perceive humanitarians to be civilian minus when they're doing quintessentially humanitarian tasks. So even the simple act of something so fundamental as delivering food aid to populations at risk of starvation, humanitarians can be accused by armed actors, for example, of helping the other side and being the wrong kind of civilian. And so in the book, I spend an equal time looking at these civilian minus claims. And I think often what humanitarians are doing is they're using the civilian plus in two modes. So one mode is to claim something special that will help them escape ordinary civilianness. But in the second mode, it's a defense mechanism to cleanse any suggestion that they merit something less than civilian status. So part of the Civilian Plus project then is about trying to escape the ordinary civilian. But another equally important part of the project is trying to claw back the promise of the civilian when it's under threat. So that's the core original contribution that the project seeks to make. And if you will indulge me, let me just check my time here to see how I'm doing. Oh, perfect. Okay, so I have about 12 minutes left. I'd like to spend a bit of time on methodology because I have a sort of a wild claim I need to make. So, and then I need to explain it. So I'll say something here about the normative question that's at the heart of the project. Then I'll delve very briefly into grounded theory, and we can come back to that later. And then I'll say something about the three realms. So the structure of this study is it follows the style of multisided ethnography. And for those who aren't familiar, what this approach does is instead of being a classical ethnography where you'd stay for a very long time in one place studying a population or a thing, with multi-sided ethnography, I skip across different global sites. So the trade-off is that it's inevitably more superficial. I spend less time in each site. I go less deep, right, than I would if I lived in a small village for 3 years or something like that. But the benefit, especially from a lawyer's perspective, is that I can show you then how a rule circulates globally. So I can track it from the ground in South Sudan to training spaces, which I propose are a middle realm, and on to Geneva and The Hague. Okay, so let me say something about the normative question. So as I was talking to you about the civilian plus, the mere civilian, and the civilian minus, maybe you became a little bit uncomfortable. I still am. I've been working with this idea for years, and it still makes me uncomfortable. Because I think the stakes are high. I think anytime, from an ethical standpoint, anytime we're talking about who should be protected from harm in war and who is a legitimate target, the stakes are very high from a material human perspective. And so I don't take that lightly. And I think that engagement comes with responsibility. And as I was building this study over the years, pretty early on, I started to have this sense, like almost lurking at like the corner of my vision, that there's something dangerous about this idea of a special civilian. And maybe it's something we wouldn't want. But I didn't want to front load my answer to that question, the normative answer. I didn't want that to front load my empirical study, because I knew if I said at the outset that we don't want to break up the civilian category, for example, then all of the practices that did so, I would judge them and maybe even exclude them. And then I wouldn't be able to show you this slice of practice that I've been able to on the ground. And so I take that normative question and I put it all the way in chapter 6 of a 6-chapter book. But if that's unsatisfying, then I will give you a teaser of how I ultimately come down on that question. So the question, do we want the civilian plus? What I do at the end of the book is I explore this question through an imaginary debate. So this debate isn't actually taking place, although I believe it should, and I'll explain why. And what I do is I set up 2 composite perspectives. So they don't represent the view of any one thinker, but they bring together different kinds of thoughts. Sorry, I just saw a question in the Q&A. I'll come back to that. So let me regroup. Where was I? Oh, yes. Okay. So the composite perspectives, right? So on the one hand, we have this view that groups together different thinkers' perspectives. And this is the help the helpers view. So from this perspective, we could say, yes, we might want to incentivize the important work humanitarians do by giving them a special status. This would recognize that they're at danger in armed conflicts that they, enter into voluntarily. They put themselves at great risk. And also that we want them to be able to do their work, right? So we want them to be able to access war-affected populations so that those populations can be served. So if we give them a special status, it will help the war-affected populations that they help. So that's very intoxicating and very seductive as an idea. And I think if we consider it in a vacuum, well, who would really argue with it, right? Of course we want humanitarian actors to stay safe. And of course we want populations in need to receive life-saving services, right? I think there's nothing very controversial about that. And so at face value, it appears like a good idea that we would green light. But what I argue is that not so fast. If we slow down and we position the humanitarian actor in relationship to the general civilian population, and remembering indeed that these war-affected populations give the humanitarian their reason for being, right? If we situate them alongside this population, we have to ask, what would it do to the ordinary civilian to give the people who provide them aid something more than civilian status? And I did not find a good legal analysis of this question yet, but I found really excellent insights from people like Larissa Fast, Didier Fasson, Monica Kraus, and others who have looked at humanitarian exceptionalism, right? And there's this whole literature on the idea of the humanitarian as outsider. And in this more critical literature, we can see that there's a risk that the humanitarian could become ever more distanced or estranged from the people she seeks to help. And so Fasson has written really lucidly about the weighing of different lives and introducing this danger that it may be that the humanitarian endeavor puts more value on the life of the humanitarian actor, which is a freely risked life, as opposed to the life of the recipient of services, which is more like a bare life, drawing on Agamben here, in need of saving. And so there's this inequality of human lives that maybe we could argue is core to the humanitarian endeavor, and it's something that must always be challenged and resisted. And what I do by bringing IHL into the equation is I ask that question thinking of the civilian category. And I think the ultimate mischief that we should at least be cautious or wary about is, if we make humanitarians special civilians, what are we doing to all the civilians left behind? And my empirical work shows in South Sudan, for example, that other international civilians, like those who do human rights for the peacekeeping mission and so on, they have noticed that humanitarian distinction practices downgrade them to a lesser kind of civilian, and they feel quite anxious about this. And so I kind of draw on that interaction, which I'm able to show exists, empirically, to think about what would it do to war-affected populations to give the helpers something extra. Now you can see why I wanted to defer that answer, because I think we can disagree about it. I think we can have good arguments and reasonable people can say otherwise and go the help the helpers route. And I didn't want that to shape the whole discussion. Okay, now you might ask, why would you build a whole project around introducing this idea of the civilian plus and then tell us it's a bad idea, right? That's the wild part. Why would you do that? And my answer to that is, well, actually, that flows very naturally from my methodological choices and from the epistemology that underpins my study. So I used grounded theory, which is an iterative process. It's both inductive and deductive. Instead of a causal hypothesis, I had a foreshadowed problem, which is simply something's going on with distinction in international practices. And then I used an ethnographic approach which sought to see through the eyes of different kinds of actors, to see their values, their motivations, their patterns of meaning. And then I did empirical work in 2015 and 2016 in South Sudan and at civil military trainings. And I won't go into that in detail, but please come back in the Q&A and I can tell you more about that. And what I did is I tried to build the empirical picture first of the distinction practices that I was noticing, and only later to judge them or assess them from a normative perspective. And of course, that's always a bit of an artificial task, but this is how I come to a situation where I'm presenting you with a new civilian who I think we should be wary of. So it's actually quite a natural consequence. And I'll just finish here by saying something about this idea of a multi-sided ethnography. So each substantive chapter of the book takes us through 3 different realms. So the first one is the kinetic realm, which is what I've termed the South Sudan case study. And this is where we find distinction in motion. So that's why I use the word kinetic. And in South Sudan, this is really the visual and optical life of distinction. Everything here is about perceptions and what's observed. And I develop an argument also, we can speak later about this idea of a phantom local, an imagined local observer who watches international actors and sees whether they distinguish themselves. So this imagined local audience. And I really show that in action in South Sudan. Then in the same chapter, we move up to a slightly more normative realm, which is the training spaces in Sweden, Italy, and Germany. And this is what I've called the pedagogical realm. And this is where where we find distinction being taught and learned and questioned and challenged. And then finally, we come to the intellectual realm. And from an IHL law perspective, you could write the whole book here, right? I think that would be recognized as the most traditional site of lawmaking. This is where we look at the Geneva Conventions. We look at decision-making at the ICTY in crimes against humanities cases and historical approaches to protection. So the entire book could have been written there. But what I wanted to show is that South Sudan, the training spaces, and the intellectual realm are all sites of lawmaking, where actors, some of whom we might not think of as legal actors, are actually producing the meaning of IHL and the meaning of distinction. And just to show you briefly, the kinetic realm and the pedagogical realm, this is where the empirical meat of the story is. And so I begin each part of the book with an encounter, drawing on Irving Goffman's idea of encounter. So it's like a distilled social interaction. And I raise a set of problems through a composite encounter that foreshadows the themes that will be discussed in that chapter. And I use the concept of everyday distinction practices to speak about the competent performances that humanitarian actors engage in on a day-to-day basis to assert distinction. And so in the kinetic and pedagogical realm, we're going to places that you might not think of as legal sites, and we're paying attention to actors that you might not think of as legal actors. And we're finding that distinction's meaning is being constituted, produced, disseminated, and challenged, right, at all levels. And when we finally arrive, each chapter, when we finally get to Geneva and The Hague, the reader might think, oh, like finally we'll get to the real principle of distinction and we'll have clarity and binary thinking and comprehensiveness. But actually, all we find are ambiguity and indeterminacy and vagueness, like so much else in international law. So I'll leave you with that provocation. And I did promise if you hung on till the end, there would be a sweet discount. So let me just go to this discount slide, and people can email me as well, or to the organizers, and I'll share it. And this is just for 30% off if you're interested in buying the book, or if you'd like, to encourage your library to get it or something like that. But thank you very much. Thanks for your time, and I'll turn it back to our lovely hosts.
Thank you so much, Rebecca. It was a wonderful presentation, and I see that it has already triggered some thoughts and reflection on the part of the audience. I will not wait any longer and share those with you. So both attendees are actually interested in the use of autonomous weapons and new type of technology in warfare, just as a background. And the first, Mohammad Janabi, asks, how can this classification of civilians be employed in most complex armed conflicts? So how can it be affected by most development weapons used in current armed conflicts, such as autonomous weapons? There are a lot of questions in one. And how can this classification affect the type of protection offered by AHL? And I think that then Dr. Marta Bo then asks a question that is highly related, maybe the other side of the coin. So she wonders, what are the implications of the mess around distinction for autonomous and automatic target recognition? And she wonders what you think about the process of encoding the principle of distinction, for example, in algorithms. And so I put these questions together because they are highly related. And I leave it back to you.
Thank you so much. Gosh, Rebecca, I almost feel like you'd be great at answering these questions, wouldn't you? These are right up your alley. So these are wonderful. Thank you, Mohammed and Marta, to both of you. And let me see if I can package this a bit together. And then I'll just say, Rebecca, are people able to speak in this webinar format or not so much?
Unfortunately not.
No. Okay, let me just say that after I respond, if the original people asking the question or anyone else in the audience wants to come in and say something about autonomous weapons, I would love to hear it, because that's not a focus of my work. So, but let me riff on it a bit and see what I might be able to contribute. Okay, so what I think is happening, if I can explain this in a more refined way. Mohammed's first question about how can we employ this mess, I think this is the mess that is already happening in complex armed conflicts. So what I'm trying to do is describe what I actually think is already happening on the ground. And I'm working backwards from the complex conflicts to tell you why we hear, like I'm just thinking of Afghanistan and the news coverage last week, and people were saying, oh, but like many people at the airports were women and children, right? And my first thought was like, what does that claim do to men who are civilian, right? Or people who might seem to express or show combatant-like or civilian-minus characteristics. And often we see it's women and children and the elderly who tend to be held up as a matter of perception as objects of special protection, who are at least by default assumed to be civilian. And then this gets really troubled in today's complex conflicts when children fight and when women fight, right? So when I talk about children fighting, I'm thinking here of work by Mark Drumble in particular, Rene Provost, Alex Singa. And when I talk about women fighting, I'm thinking especially of Judith Gardam's work and Orly Stern's work on female perpetrators in conflict. And so when these people who tend to be thought of as more pure or more eligible civilians as a matter of perception, when they fight, we can see where the trouble is, because suddenly, well, are there any civilians left? You know, who's left as a sort of untainted civilian? And so I'm not suggesting that we take the plus, mirror, minus framework and apply it in a place like the Congo or Mali or Myanmar. I'm saying that's what is happening in those places. And to understand that, we just have to hear people in the operational context. They'll talk about people being the wrong kind of civilian, right? Or they'll say a certain group of civilians is loyal to the opposition, and therefore, you know, it's implied that maybe they could be targeted. So when we think about autonomous weapons, my first observation is, I'm not sure humans have always been particularly good at parsing who is a protected civilian under this framework. And you would think, you know, there's a possibility that the more distance we get, once we're talking about programming algorithms or something like night vision, where you're physically, you know, more distance, or you're getting away from the heat of battle and like maybe looking through a little telescope or, you know, something really distant, you would think we would become, we'd have a more objective analysis. And in theory, maybe we could slot things into this elegant binary. But my hang up when we start talking about autonomous weapons is whichever side of the debate people fall on, whether they're in favor of their development or wary of them, they don't seem to have a clear picture of what humans were doing with distinction, and or what humans were doing with IHL more broadly. And my kind of discomfort around this has led me to my work on emotions, because when we talk about removing the human from the loop, or taking the human out of the decision making by maybe relying more on an algorithm or something, my question is, I don't think as lawyers or as scholars or policymakers, we've yet figured out what it is that humans do with IHL. And we don't know how human things like frailties around hunger or revenge or jealousy have shaped people's judgment about who is civilian and who is combatant, right? So I'm like incrementally working on that problem and looking at perceptions. But to say something more directly about encoding, I'm not sure about encoding because I'm just not an expert on this, but I have been in the room at the University of Edinburgh for really interesting conversations that are being overseen by Professor Nehal Bhuta on this question. And so there are teams of people under a Carnegie grant there, and they're looking at algorithms and IHL rules. And they have this project, I think it's called something like Rule of Law, Technology and the Rule of Law. And they're actually looking at these questions, working with people from industry and from the tech sector on whether you can encode legal rules and ethics into algorithms. So I'll leave that as like a question mark, but if anyone from the audience wants to add on to that, I would love to hear, because I would not say I'm at the cutting edge of autonomous weapons thinking on this. So I'd love to be corrected or updated as well. But thank you, really nice questions, Marta and Mohammed, thank you.
Thanks, Rebecca. But I think your work actually helps this kind of discussions on how encoding might be straightforward. On the contrary, quite complex when you see with your spectrum how varied the civilian identity can be, let's say. So it adds a whole layer of complexity to the encoding process or attempt, I think, when you see reality as you describe it so sharply in your book. So we have a question from Claudia Klanowska, who is a PhD candidate in international law at the Asser Institute. She thanks you for your brilliant critical presentation, and she asks you, so she's at an early stage of her research, and she's wondering about the research methods that you shared with us. Especially, she asks, how can we observe IHL or international human rights law in action, and the difference you mentioned between instrumental and constitutive functions of law on the ground? Can you share some examples of the type of empirical methods you used, interviews or observations, to understand these two functions and distinguish them? Thank you in advance. And then just putting this, going a little bit backwards, Marta replies with just a comment. This is very interesting. Thanks. In particular, your work on emotions and IHL. I think it has a bearing on how automation bias work and might affect judgment and decision-making in targeting. I leave it to you.
Oh, thank you, Marta. That's really useful. That will keep me inspired to not to keep engaging and learning more on the technical side of it. So thank you for that. And can I just say, these are amazing questions. I love this group of people, really fantastic caliber of engagement. I feel really lucky to be part of it. Claudia, thank you so much. I love talking to PhDs. So let's talk a bit more about methods. And thank you for giving me a chance to do that. Let me just see examples of empirical methods. Yes, okay. Yes, okay. So let me say more about the methods first, and then I'll clarify something about sociolegal approaches, because I think you could use many of my methods and not take a sociolegal approach. So I'm sort of mixing sociolegal approaches with what social sciences might do in like a qualitative empirical project. And that's just because that's how my brain put this problem together. And that was the toolkit I wanted to use. But there's not necessarily a need for people interested in studying practice to take a sociolegal approach. So let me just say that. But now let me talk about methods. So if we want, the big question, right, is how do we study IHL in action or IHL on the ground? So I cheated a little bit because I was on the ground as a practitioner for a few years before I did my project. And what that meant is that I had this sort of advanced engagement of what anthropologists would call participant observation. So if you're taking an anthropological approach, participant observation would mean that you're in a space, and it could be like a place like a conflict zone, but it need not be, right? And it could be like a bureaucratic meeting, as people who study the World Trade Organization will tell you, that you can do a participant observation, ethnography of a staff meeting at your law school or whatever, right? So any space could be a site of everyday life where we're looking at law in action. So let me just clarify that in action doesn't have to mean in the heat of combat. But it happened that I had lived in an active war zone, and I felt that gave me a certain set of unique insights. And it also made me like a mature student. So I was always like way older than my fellow students. So it's always like, they keep getting younger, like my colleagues, so I'm getting older. But so it has its drawbacks, going back between theory and practice. But so techniques, I paired participant observation. So that would mean at the trainings, for example, I did 200 hours. So what that meant is I thought that was a good amount of time to hang out with NATO soldiers and UN peacekeepers. And I wanted to spend a lot of time with them because I come from a civilian humanitarian mindset. And I knew that would be like my bias in the study. I would be sympathetic to humanitarians and maybe less sympathetic to actors who use violent means to get things done, right? So I knew that if I wanted to really paint a picture of a 360-degree struggle over distinction, I needed to get in the room with the people who humanitarians are trying to, distance themselves from. And it was a total accident how I discovered this. So I was invited to give a training in a civil military training in West Africa. And as a trainer, I started realizing that training spaces are a place where IHL was being taught and questioned and challenged. And where I got really lucky, and I never would have thought of this, it just happened by accident, is I started watching role plays and simulations. And as a law teacher, I've always been interested in experiential learning, and I do it in the classroom, but I had never thought of watching in like a iterative, repeated way, watching how practitioners do simulations. And so at NATO and at Sweden and at the German Center, I watched as practitioners role played distinction. And in one case in Sweden, it was virtual reality. So soldiers would engage with a fake, virtual NGO worker on screen, and they'd have to yell out like what the player should do next, like how the soldier should behave. And then they would go into an adjacent room where an actor played the humanitarian, and the soldiers had to try to get the humanitarian to work with them. And they were learning how to work with civilians. And when someone did something wrong, they would like pause the action, repeat it, and as I watched that, I just was writing it all down furiously and recording it. And I didn't understand what on earth I was going to do with it. But then I realized I was like watching distinction in slow motion. So that going to these trainings and watching these totally artificial simulations was letting me observe patterns of interaction that I would never see in Darfur or South Sudan. Because in the heat of a conflict setting, you can't like press do over much as we would often want to, right? And so that was accidental. But what it led me to do was I started doing perception surveys where I would ask soldiers and peacekeepers how they thought humanitarians saw them. That helped me shape interview questions. And at the end of their trainings, I would ask them if they'd be willing to have like a small focus group with me. And in the focus group, I'd ask the questions that the perception study suggested might be like ripe. And then I just went back and did it at a few different places that would allow me access. And getting access was the hardest part. But in all cases, I would reveal myself as a researcher from the outset, right? Nothing was covert. And that's really, from an ethical standpoint, that was really important to me. So I paired perception studies, participant observation, and interviewing. And I did that in South Sudan, and I did that at the trainings. And then I wrote it as a PhD on, IHL in action. And then I rewrote it almost totally as the book. So it wasn't until I finished the PhD that I could see, oh, there's actually this more elegant story from the bottom up I could tell. So I would just say, as a PhD student, don't feel like you need to do it all now. It might only be once you finish and pass the Viva that you can look at the project and say, oh, that's my claim. And, it becomes more refined and elegant over the years. So yeah, and I would just finish by saying you do not need to mix that with the instrumental and constitutive, but I did because in South Sudan, people were not talking about IHL, but they were identifying as civilian, and they were trying to assert a distinction by everyone they thought was either the wrong kind of civilian or a combatant. So I needed to think about law having a constitutive or constitutive role. And I didn't even know about that. I had to go learn it in the books after I saw it in practice. I had to teach myself and learn from people like Linda Mulcahy and Meredith Rossner at the LSE who taught me sociolegal methods. I didn't know them. I didn't know what I was seeing. So I learned it after, if that makes sense. So but I do go through it in the book and the PhD. If you want to read the chapter on methodology, I do walk through it. Long answer short, yes, good luck.
Thank you so much, Rebecca. And I'm sure, Claudia, if you have more questions, I'm sure Rebecca will be happy to discuss as well. But the book is also a great source of inspiration. Thank you so much, Rebecca. I don't see any more questions coming, and I think I'm also conscious of time, and I think we had a really wonderful conversation following your great presentation. So I just want to thank you wholeheartedly on the for your time and for sharing your findings, the findings of your book with us. It was really a pleasure.
Oh, thank you so much, Rebecca, and thanks, James, as well. And to our fearless admin folks in the background who you can't see today, to Leah and Eva. And let me just say thank you, Claudia and Odette. I just saw your comments in the questions there. And you guys are fabulous. This is really great. And please do feel free if your projects relate or you want to reach out. I'll share my email with Rebecca and James. And so if you want to get in touch and follow up, I'd be very happy to do that. I always learn from these engagements myself as well. So thank you for your generous engagement. Thanks for having me.
Thank you, Rebecca. And we will see you all, I think, in November. I think it's on the 11th of November for a discussion on due diligence and IHL with Erica Gaston and Marco Longobardo. We will keep you posted about that. James is in charge of the whole organization of this this next HILAC lecture. So we will keep you posted. And until then, we keep in touch. And thank you so much again, Rebecca, for this great presentation and discussion. Thank you, everyone, for your engagement.
Thank you all.
Thank you.
Take care.
Good luck this autumn.